All right, let's talk about something tricky. What happens when the very people who are supposed to enforce the rules just don't? Today, we're going to break down this incredible story. It starts with a pretty simple neighborhood dispute over some dirt, but it spirals into a full-blown legal battle that puts an entire HOA on trial.
You know, this is a huge question for anyone who lives in an HOA community, right? You buy your house, you sign all the papers, you agree to play by the rules. But what are you supposed to do when the HOA itself just decides to look the other way? What's your next move? Well, we're about to find out.
Okay, so let's set the scene. We're in Sierra Tortuga. It's this small, pretty exclusive community, just 14 custom homes tucked away in the hills of Tucson, Arizona. And you gotta picture this place. The whole point is that the homes are designed to just blend right into the natural desert. And that landscape, that is key to this whole story.
So the whole thing gets started back in 2020. A couple, the Morcombs, start seeing some major construction happening right next door on Lot 9. And I'm not just talking about a little gardening. We're talking native plants getting ripped out, the land being completely regraded, and these huge boulders being brought in. And all of this is happening right up against their property line. Now, if you live in a planned community, you know all about this. Every single homeowner in Sierra Tortuga has to follow a specific set of rules. They're called the Covenants, Conditions, and Restrictions, or CC&Rs for short. You can basically think of them as the constitution for the entire neighborhood. They're legally binding.
And this is the rule that kicks off the whole mess. The CC&Rs are super clear. There has to be a 25-foot setback from every single property line. It's like a buffer zone. And inside that zone, you can't make any improvements, you can't even take out native plants without getting it all approved by the HOA's architectural committee first. The big problem? You guessed it. All that work on Lot 9 was happening smack dab in the middle of that 25-foot zone.
So the Morcombs did what most of us would do. They tried talking to their neighbors first, to work it out, but that didn't go anywhere. So they did the next logical thing. On June 13th, 2020, they filed a formal official complaint with the HOA board. The ball was now in the HOA's court.
And at first, it really looked like the process was working exactly like it should. The HOA board actually started a formal investigation. They went and interviewed the owner of Lot 9. And get this, the guy admitted he never even submitted plans for approval. I mean, sounds like an open and shut case, right? Okay, so fast forward to September 3rd, 2020. The investigation is done, and the findings are crystal clear. The report confirms it. The owners of Lot 9 totally made unapproved improvements inside that 25-foot setback. So the board tells them to stop all work immediately and gives them 30 days to get their plan submitted for approval. Seems fair. So that 30-day deadline comes and goes. Then a whole year goes by. Then another year. And the whole time, those boulders, that graded dirt, the entire violation, it's all still just sitting there. And what did the HOA do about it? Absolutely nothing. Crickets. They didn't enforce their own decision. Yeah, this timeline just lays it all out, doesn't it? I mean, can you imagine? After waiting for almost 3 years, the Morcombs were just done. So in April 2023, they lawyer up. Their attorney sends a formal request for all the HOA records about this whole mess. And when the HOA still does nothing, doesn't even send the documents, they were left with no other choice. They had to take it to the next level and file a petition with the state. And this is where the HOA's headache got a whole lot bigger. Because by ignoring that request for documents, the Morcombs could now argue that the HOA wasn't just failing to enforce its own community rules, it was now breaking actual Arizona state law. There's a specific law that says HOAs have to hand over records to members within 10 business days, and they just didn't. So all of this leads to the big showdown in late 2023. We're talking a formal hearing in front of an administrative law judge. You've got the Morcombs on one side, and on the other, their own homeowners association. It's homeowner versus HOA. And this is where you can really see the two sides of the story. It's fascinating. The Morcombs' argument is simple. The HOA has a job to do. They have to enforce the rules in the CC&Rs, and they failed to do that for 3 years, plus they broke the law by not giving us the documents. But the HOA's defense was interesting. They basically said, well, our rules are kind of poorly written, and we haven't always enforced them anyway. They tried to frame it as just a petty fight between neighbors, and they claimed they couldn't provide the documents because they just didn't exist. Okay, so the judge hears all of this. Both sides make their case. You've got all the evidence laid out from that very first complaint all the way to the HOA's own investigation report. So where does the judge land on all this? It really all came down to this one question. Was there a good reason for the HOA to do nothing for 3 years, or did they just completely drop the ball and fail to do their job? And the decision was a total win for the Morcombs. The judge said they had absolutely proven their case. The verdict came down, and the HOA was found in violation on both counts. First, for failing to enforce its own 25-foot setback rule, and second, for breaking state law when they didn't hand over those documents. And yeah, there were financial consequences. The judge ordered the HOA to pay the Morcombs back the full $1,000 it cost them to file the case. So the HOA had to foot the bill for being taken to court. So when you boil it all down, this whole case leaves us with a really important question, especially if you live in an HOA. Are the rules just suggestions, or is the board's job to enforce them an absolute duty for every single resident? Well, this verdict out of Arizona gives a pretty strong answer to that question. Thanks for digging into this with me.